Hello, I'm Dan Marr from the Nashua law firm of Hamblett Kerrigan. I've been an attorney in New Hampshire for approximately 36 years and in Massachusetts for 28 years, practicing both states. And today I'm going to be talking about in New Hampshire when one spouse can be liable for the debts of the other spouse. And we're going to talk about that in some detail. I'm going to first jump into the issue of medical expenses. In New Hampshire, there's the doctrine of necessities that basically, and the Supreme Court has dealt with this, New Hampshire Supreme Court has dealt with this um, throughout, and makes it equally applicable to both men and women for both spouses. So in this situation, if one of the spouses needs medical care and their medical care can't be provided for by can't be paid for by that spouse, and the medical provider first tries to collect from that spouse, and they're still the husband and wife or the spouses are still together, then the other spouse can be held liable for it. In that situation, it can be quite concerning if one spouse goes into a nursing home or there's huge medical bills that are not covered by insurance. That can be devastating to the family, and you will sometimes see, not infrequently, in that situation, particularly when the spouse that's in the facility doesn't have the mental capacity to understand what's going on, particularly in that situation, there's a divorce, and the divorce is to protect the family assets. There might even be a divorce with the other person in the facility understanding why the spouse is divorcing them to get around this doctrine of necessities of the ongoing obligations that are there. Now, that can't be a farce, of course, but if it's a real divorce to separate to protect the assets, that might work in that situation. I'm not suggesting it, I'm just saying that in that situation for medical expenses, you can be liable for that. Generally, otherwise, you're not liable for the debts of your spouse. If one spouse has a credit card and you're not on the card itself, you're the spouse and you're not on the card itself, the credit card company can go after that spouse's assets, but not yours. Same with business debts. If one spouse signs a guarantee for, they have a restaurant, say Jack and Jill are married and Jill has a restaurant and she signs a guarantee for the landlord and guarantee for the loan for the build out of the restaurant fails, they can go after Jill's assets, they can't go after Jack's. Just because Jack is married doesn't make him liable unless he signed a guarantee, and maybe a landlord suggested that he needs the wife and husband on it, and if they make the mistake of doing that, and I don't have that situation when I have clients and the commercial landlord says, no, we demand the spouse on it, I say, you don't have a deal. So I think you should try to do that. But if you don't do that, and the spouse is on the guarantee, then they can be liable. Absent that, they can't be. One situation upon which, outside of medical expenses, the husband or wife can be liable for their other spouse's debts is fraudulent transfers. In a situation where say Jill's restaurant is not doing well, and Jill has from her family a lake house, and it's been in her name, and she transfers it over to her husband because she doesn't want the lake house to be subject to the creditors of the restaurant, being the landlord and the bank or anybody else that's able to go after Jill for the restaurant failure. In that situation, that transfer could be a fraudulent transfer. It's made to an insider, being her husband, and it's made probably as a gift, so that they can get around paying these debtors, these creditors of this debt. And in that situation, that's not going to be sufficient. You're going to be able to get around it. Also, say there's an example where husband lent to Jill, and they even had a promissory note, and they did it all the right way. They went to an attorney, and they had a promissory note done, and he loaned from his own funds, from a separate bank account, to Jill money for the business, and then Jill goes and makes sure she pays him back and leaves the landlord and the bank high and dry, maybe tries to file for bankruptcy or just is insolvent in that situation. That's called an insider fraudulent transfer, and there's a specifics under the fraudulent transfer statute. You can talk to a creditor's attorney, and you can find out about how you can uncover that too, for when husband has a legitimate debt, but he got paid as an insider before wife's other creditors got paid. So that's something to discuss when the spouse can be liable for that. I've also seen in situations where there's a divorce, and a legitimate divorce that happens. Say Jill's restaurant financial problems drove them such strife that they had falling out and they couldn't reconcile. They had irreconcilable differences from this, or maybe she took off with the chef of the restaurant and she had a paramour, or whatever the reason may be. It's a real divorce going on, and as part of that divorce, Jill agrees that the joint debt of them, say there's joint credit card debt, or they both signed on the guarantee of the lease of the commercial landlord, that Jill is solely responsible for the obligations to the landlord. That deal in the divorce is between Jack and Jill. It's not between the landlord and Jack. So Jack is still liable to the landlord if he signed a guarantee, and the landlord, and I represent the landlords often in situations, will go after Jack, and the divorce decree will mean nothing to the court or to the landlord, and the landlord will fully enforce it because the divorce decree is not something that binds the landlord. If you have questions in regards to any of these matters, you can call me at 603-883-5501, our firm website, or check out